would you like to go next?
Excuse me, Mr. Chairman, members of the commission, including Mr. Perini out there in Pittsburgh.
How are you, sir?
How are you? I'm doing good.
With us.
And Solicitor Finucci. My name is Donald Miles. I am an attorney. I live and work in Bethlehem, Pennsylvania, in Lehigh County. And I represent 21 of the residents of Jessup in opposition to this curative amendment. I don't want to have to correct my friend Mr. Finucci, but the statute refers to them as objectors, not protesters.
Well, there's reference to protesters. There is. I'll show it to you, but thank you.
No offense.
No harm intended.
I've been a zoning attorney for 38 years, and I spent 24 of those years sitting on the other side of a planning commission table as a planning commission solicitor, municipal solicitor in Lehigh County, in the fastest growing municipality in that county. And in that capacity, I represented the township in defense of its zoning ordinance when challenged in curative amendments, and I've also represented objectors who have defended challenges by landowners to zoning ordinances. And I'm pleased that in every instance where I was involved on one side of the table or the other, the argument that I advocated was successful, both in the municipality and in the county courts. I'm sure you realize that whatever happens, this is likely to wind up in Lackawanna County Court. Since, as I said, I was a planning commission solicitor and handled curative amendments, you've probably already been explained this by Solicitor Finucci. But what's going to happen at the hearings before the Borough Council is Attorney Finucci is likely to be the hearing officer, and he will run the hearing for those people that will be speaking and set the rules. And then ultimately, the council, after asking questions, will take a vote. It's likely the hearings will have multiple sessions. But in all of the curative amendment proceedings in which I've been involved, either representing the municipality or representing people who are defending the municipality from a challenge by a landowner, which is what's happening here, the planning commissioners of those municipalities ask permission of the municipality to hire their own experts to present a defense of the municipality's zoning ordinance, and to hire an attorney to make that presentation. As hearing officer, Solicitor Finucci will not be in a position to defend the ordinance. We will be defending the ordinance, but you should have someone who has done the expert work to inform you about whether this ordinance is invalid or not. And you should not rely on my clients and our experts, just as you should not rely on experts from Invenergy. We could not afford to have our experts here to speak tonight. We can only bring them once to the hearing. But even if we could, as I said, you should not be listening to what we say the facts are. You shouldn't be listening to what Invenergy says the facts are. You should gather the facts yourself. You should ask the Borough Council to give you time and money to hire your own land use planner, independent, not the county land use planners, an independent land use planner, to evaluate whether what they say is invalid with your ordinance is in fact true. And you should hire special counsel to present those findings at the curative amendment hearing. Let me talk about what Invenergy has alleged, and I also want to touch upon what the Regional Planning Commission did. The Regional Planning Commission made the recommendation that Solicitor Vanucci read without having any facts. They based that opinion on what they were told by Invenergy. They had no independent knowledge of what the facts were. Our experts will testify at the curative amendment hearing that your zoning ordinance is not invalid. Not only can a natural gas-fired electric generation plant be built in the M2 zone, despite the restrictions that have been noted, they could build this plant in the M2 zone. And as you know, there's a two-stage process in the curative amendment proceeding. Stage one is the ordinance invalid? If it isn't, it's over. If it is invalid, then the council has to decide what to do about it. Now, the borough decided years ago that they wanted an electric generation plant in the M2 zone. That was a legislative decision. That decision should not be challenged by the Regional Planning Commission. It should not be challenged by anyone except the borough if they decide they made a wrong decision. But there's no evidence yet that they did. They did not list as a use in the M1 zone where Invenergy wants to build this plant, electric generation plants. As was noted in the opinion of the Regional Planning Commission, the M1 zone has uses of compressor stations, utility buildings, storage of gas. It contended that those were of the same scope and intensity of a natural gas electric generation plant. That statement convinces me that they know nothing about what a natural gas electric generation plant is. It is nothing like a compressor station, which is a few turbines that keep the pressure in a gas transmission line up to regulation standards. It is not a public utility building. It is a very large facility. However, that facility could be built in the remaining land that is outside the 2,000-foot restrictions in the M2 zone. In fact, even a larger plant could be built there. But as I said, I'm not an expert. You heard me say that. You don't have that evidence. They didn't produce any expert testimony either. You need to get your own expert testimony so that you can make the recommendation. Right now, the only recommendation that you could make based on having no evidence is to recommend to the Borough Council that you cannot recommend that the ordinance is invalid because you have received no expert testimony to tell you whether a natural gas electric generation plant can be built in the M2 zone. Also, even if it can't, you need to have a land use planner speak to you as to why, instead of having it where the borough decided years ago it should be in the M2 zone, it should move to an entirely different zone. You know, coming here for the second time, I went up on the hill and I looked at the M1 zone. The first sign you see is the Jessup Small Business Park. This is no small business. This will be one of the largest natural gas electric generation plants in Pennsylvania. I should also note that it will be a larger plant than Invenergy has ever built, and they have never built anything at all in Pennsylvania. And I'm afraid I have to note the irony of what is permitted in the M1 zone in the office park. What is permitted there is a wind farm, a wind turbine farm, like some of the wind turbines you can see here in the Wyoming Valley. It's particularly ironic when you go to the Invenergy website and you see that 60% of the megawatts in electric generation that they have built so far has been wind and solar. They don't want to build wind and solar in Jessup in a zone where they bought land and where it's zoned for. They want to build an electric generation plant in the M2 zone, where your borough decided long ago it should be, and where we will show at the curative amendment hearings that it can be built. Once again, I'm beating a dead horse here, but don't take my word for it. Don't take their word for it. Ask permission to hire your own land use planner and your own electric generation expert, like we will have, to tell you whether or not a plant could be built on the land that is outside of the 2,000 foot setback. And I'm not going to take any more of your time. I know it's been a long night. I just have to mention about the issue about variances. To get a variance of the 2,000 feet, to get a variance of the 70 feet height, to get a variance that the whole thing has to be in a roofed building. By the way, about 75% of these things are in a roof building. There's just a little bit that is outside. All of that would easily be a variance. If you can get variances to deal with your problems, you can't say that the ordinance is invalid and that it's discriminatory. They have said that Jessup Borough has zoned out electric generation plants. Your borough has not. It can be built in the M2 zone either with variances or without variances. There is an attempt here to use a false argument about your ordinance being invalid to build what they want in a place where your borough said they don't want it, up on the hill in the M1A zone. There are arguments that the M2 zone can't handle this and that therefore should it be in the M1 zone, or what my late Irish grandmother used to call bowls of blarney. I just want to, for the record, read the names and addresses of the folks that I represent so that it's clear that they participated at this stage of this process. Pat Bryla, 1104 Spring Street; Gerald Crinella, 1204 Tonwin Street; Kathleen Fiorelli, 705 Powell Avenue; Peter Larioni, 1123 Church Street; Corey Mahan, 199 Front Street; Gloria Mraz, 118 Center Street. Excuse me. Angela Mushall, 926 Court Street; Janine Pavallone, 407 4th Avenue; Joyce Pavallone, 407 4th Avenue; Jason Petrachko, 117 Center Street; Holly Petrachko, 117 Center Street; Joseph Picconi, 601 Grassy Island Avenue; Richard Sakulich, 900 Grassy Island Avenue; Rella Scasalati, 300 Grassy Island Avenue; Cynthia Sebastianelli, 130 Palmer Drive; Helen Sebastianelli, 125 Buttonwood Street; Ronald Sebastianelli, 130 Palmer Drive; Sam Sebastianelli, 125 Buttonwood Street; Lisa Simon, 203 Front Street; Rita Stella, 603 Grassy Island Avenue; and Anthony Wrightson, 215 Grassy Island Avenue. I appreciate your allowing me to speak to you on behalf of those 21 folks that I'm representing as a volunteer attorney. And I urge you to make no recommendation tonight. If you insist on making one, the recommendation I hope will be that you do not have sufficient evidence to conclude that your ordinance is invalid, since you have had no evidence presented to you. Just my arguing and their arguing, and unsupported recommendation by the Regional Planning Commission. A 4-2 vote. One vote changes there, and they don't have a recommendation at all. And that you hopefully will recommend that the Borough Council allow you to hire special counsel and to hire an expert land use planner and an expert on electric plant generation siting to tell you whether or not this zone, M2, could support this plant, and if not, whether the plant should be in the M2 zone where your borough has decided it should be, or whether it should be moved across up onto the hill in the M1 zone in the Jessup Small Business Park. Thank you very much.
Attorney Miles, can I just ask some clarification? When you indicated that they should, when you hire special counsel, and I'm aware of the provisions in the MPC that allow the
Sure.
municipality to do that, and you correctly stated that I will serve as the law directs as the hearing chairman and advisor for that hearing, but you're suggesting council hire special counsel, not the planning commission?
No, in the past, what has happened is that the municipality has authorized its planning commission, and the MPC allows the planning commission to expend money with the permission of the governing body, and that it allows the planning commission to hire counsel and experts, and that the planning commission act as the defender of the ordinance.
Wouldn't council would have to do the hiring though, because this body has no authority to appoint or
Well,
hire.
the
Council would have to do
the
it.
MPC gives them the authority to hire if the governing body allows them to.
That's my point.
Yeah.
Okay.
Now, they can't do anything without the Borough Council saying so, but the Borough Council can give authorization to the Planning Commission to hire a lawyer and to hire experts at some amount of money that they say. And that's typically what happens, and it's not yet happening here.
And I just want to, well, one more thing. I want to ask another question, but just for clarification, this parcel that's proposed, I know is not within the Jessup Small Business Park. It's adjacent to it. It's independently owned, separate land. And the other thing is,
I think that's the sign you see when you turn on the
I
road.
believe, yeah, it's right there, yeah, without a doubt. But the variances, I have a question about your comment about variances, because I'm of the understanding that variances are not the norm, and that, you know, you have to prove all of, 5 or 6 different elements to be entitled to a variance, because it was my understanding they would never be entitled to get a variance for this type of a thing. So could you just maybe expand on that a little more?
Well, we'll have to agree to disagree on that.
Okay.
In my experience, in the 24 years I was working for the municipality I worked for, they granted about 95% of the variances people brought. So I don't think it was that hard.
What would the hardship be?
Hardship.
Yeah, one hardship is one of the elements that they would have.
The hardship is these restrictions, that the restrictions are unreasonable,
Yeah.
that they're too low, they don't need to be that far away from residences. They could be 1,000 feet instead of 2,000 feet. You can't put one of these things entirely in a building. You can only put about 3/4 of the stuff in a building. All those things are hard.
Matt, though, and I'm not challenging you, I'm just trying to, because I was really of the opinion that a variance would never be appropriate in this situation. So I'm curious as to, maybe you and I could talk more about that.
Sure. Thank you.
Okay. Oh, last thing. Borough Council did, just so everyone's aware, if you're not, did in fact hire a planning consultant. They've engaged the services of Dr. Mark Broderick. Who will be Dr. Mark Broderick. He's our land use planning consultant.
I would just mention that there's a lot of talk about how quickly this has to go. There's no time limit on a curative amendment proceeding. As long as it starts within 60 days, and this one will, they go on a long time. There was a curative amendment proceeding in Northampton County that ended 2 years ago after 5 years of hearings. There was a curative amendment proceeding in Lehigh County that went on for about 6 or 7 years. I'm not suggesting this will do that, but you would have plenty of time to have your own experts tell you whether or not this ordinance is invalid. And although a land use planner would be helpful, a land use planner is probably not going to be able to tell you whether an electric generation plant could be built in the land that is outside the 2,000-foot zone. You probably need somebody who's familiar with the electric generation industry to do that. And if that means that you need time to be able to present that evidence, that's fine. The April 27th hearing is not going to be the last one. Thank you.